The Consumer Financial Protection Bureau issue, October 10 is going to be a modification. Have y'all seen that to TRID?
Right.
In the past, the loan officers couldn't provide this closing disclosure or what's the other one? I think there was some other document they couldn't provide to the agent. They could only provide it to the buyer. And it was against the law if they provided it to anybody else. Well, all over the country, people are going, wait a minute, I can't tell whether this deal is going to close or not because we don't have this information from the lender. I call the lender, they won't share anything with me. We've got a provision in here in paragraph, you find it on page 2, under C, loan closing costs and prepaids. That last sentence, buyer shall promptly deliver to real estate agent for buyer, if any, a copy of all loan estimates and closing disclosures upon receipt. The buyer can always give it to somebody else. The lenders are confused by saying, well, the buyer can't do that. You can't force the buyer. TRID says the buyer can do it any day they want to. It's just that the lender can't do it. And now they're changing it. I think it's effective October 10, I believe, that the lender can do it.
Like
Yeah, the lender can do it.
We took the paragraph out. I know we added the language back in about, on the very last line of item 30, used to be a paragraph basically on its own, where it says any prior written agreement concerning the payment of commission or what. We used to have a brokerage fast. I think it was 26 or 28.
Yeah.
Was there a reason we did away with that and put it in?
It was
in here?
It was unnecessary, and let me explain why I felt it was unnecessary. First of all, you're not a party to this contract. Agents are. Agents not a party. Agents are witnesses. Agents are facilitators. The parties of contract and the buyers are sellers. You can't, for example, you can't say, I'm the listing agent, I'm going to sue the buyer to buy this house. You know, so you're just not, you don't have standing to do that. The old provision in reciting commissions is referring to an agreement that the listing agent or the buyer's agent has with their respective client. You've got a listing agreement. That's what you would enforce, not this contract. And so what we said in the new contract, the last sentence, where we say, paragraph 31 on page 10, that any other understanding, agreement, promise, or representation concerning the property not stated in this contract is of no effect, except the prior written agreement concerning the payment of commissions. So if you've got a listing and that's what you enforce. If you came to me and you said, I'm the procuring cause, I'm entitled to my commission, I would say, where's your listing agreement? And we would sue on the listing agreement.
Okay. So it's kind of the same thing, it's just in...
Yeah, we were trying to take out some language that really wasn't necessary, and that was the whole reason for that. On that page 2, you see the part that in bold, it says no terms of this finance contingency can be changed without written authorization of seller. There's a reason. I mean, people ask why that's in there. It has to do with the VA, FHA, and conventional. It's simply that, because of the requirements that the VA may have with regard to repairs, lender required repairs, and it's also some sort of fee they charge.